Welcome once again to Lehto's Law. Here's Steve Lehto.
A couple people tipped me off the story out of Wyoming involving civil asset forfeiture. I went and read the stories I could find on the internet about it, and all the stories I read seemed to be unclear as to exactly what happened. And so I went and pulled the actual opinion from the Wyoming Supreme Court and read it because I figured that's the only way to really get the bottom of what's actually going on here. And so I have in my hand here the 8-page opinion. And it's interesting for a variety of reasons, not the least of which is I've mentioned before that civil asset forfeiture is a very unusual legal action because the state will take the money from you at the roadside, the police will, and they'll say, if you want your stuff back, sue us. And it can be other things besides money, but it's almost always money, cash, currency. And so I've mentioned before that an action, a lawsuit for civil asset forfeiture, quite often is captioned as the state versus the money. And it's a legal fiction that you sue the money and the money must defend itself. Now, a party that says it has a right to get involved can act as a claimant, but the party, technically speaking, is the money. And I've had people say, Steve, that's stupid. And you're clearly pulling our legs on that collectively, those of us who watch your videos. And I say, no, it's actually true. The case caption I'm looking at right now is in the Supreme Court, state of Wyoming, has a case number, October term 2021, in the matter of U.S. currency, totaling $14,245. That's the first party, the U.S. currency. And then it says Elias Orozco, appellant claimant, versus the state of Wyoming, plaintiff. And a lot of times on appeal, they'll switch the case caption so that you can just guess who's bringing the appeal by who's first. So in this matter, the people who filed the original claim were the people of the state of Wyoming. State of Wyoming was the plaintiff. Now they're the appellee. And the defendant or the subject, it would actually not be a defendant, but the subject of the original lawsuit was the currency itself. In the matter of U.S. currency totaling $14,245. And Elias Orozco was the claimant. So he stepped in and said, I want to get involved. Now, he loses the case and the money. And to understand this, it gets kind of convoluted, for which I apologize. Not all cases are nice and clean, but this is happening in a district court in Carbon County in Wyoming. And so you got to go back to the story as to exactly what happened. And Mr. Orozco was driving in October of 2019 on I-80 in Carbon County when a trooper pulled him over and said he failed to maintain his lane. After speaking to him for a few minutes, he asked him where he's going. He says, I'm driving to California. The officer glanced around the minivan he was in and said, I don't see any luggage. Can I search your car? And Mr. Orozco apparently said, sure. So the trooper called in backup, so there's two guys searching his car, and they found $14,245 stashed in the back someplace near the spare tire, which they found very, very suspicious because the money was in rubber bands. And as you know, rubber bands are a gateway to bigger crimes. So they then seized the money, seized the van, took it to a state facility and dug through it some more. Didn't find anything else. But they then did show the money to a dog and ask the dog's opinion. And the dog rendered its professional opinion that the money was somehow related to some kind of drug activity. They then went and got a warrant, and the warrant was based partly on the fact that dog had said, yeah, that money there is tainted. So the state filed a complaint against the currency, seeking to forfeit it to the state and to terminate any interest that Mr. Orozco or anyone else might have to it. Now, here's the problem. Mr. Orozco defaulted. He did not answer the complaint timely. And that's a problem. And I've mentioned this recently, actually, that if you get served with a lawsuit, the summons will often say right on it, you've got so many days to answer. If you don't answer in that time, bad things are going to happen. The other side might just win the lawsuit. And so he didn't answer it timely, but he did timely move to set aside the entry of the default, and the court granted that. Said, fine, we're going to let you come in here and have your day in court, and we're going to let you argue about this. Now, here's the thing. Mr. Orozco and his attorneys decided to take a very unusual tack in this case. They moved to dismiss the complaint for lack of subject matter jurisdiction, claiming that because the amount in controversy was less than $50,000, the circuit court had exclusive jurisdiction. Exclusive jurisdiction, and $50,000 is apparently the magic number. So they're saying if it's below that, it goes to circuit court. If it's above that, it goes to district court. And I have to explain it a little bit, I guess, because this is common in a lot of states where they have different levels of trial courts. So in Michigan, we've got a very similar sounding situation, but I think it's backwards. But in Michigan, we've got circuit courts that cover generally counties. Most counties have a circuit court. Some of the less populated counties are merged together to be a circuit court for several counties. But for the most part, Oakland County Circuit Court. And within Oakland County, there's a bunch of district courts. Pontiac District Court, Royal Oak District Court, Southfield District Court. And the lower courts have jurisdiction that's lesser when it comes to like money damages. So if you're suing someone for $1 million, you file it in circuit court. You're suing them for $300, you sue them in district court or small claims. And the courts have separate jurisdictions. And that's just simply talking about the money in question or in controversy in a lawsuit. They also have different jurisdictions. Otherwise, circuit court, for instance, can oversee a divorce. A district court cannot. A district court does landlord-tenant stuff. Circuit court does not. And so they've divided up the jurisdictions on these things. But when you look at a complaint, if it pleads a dollar value, it's got to be above or below a certain number to put it in one of those two courts. And so what Mr. Orozco is saying here is that the amount of money in question meant that it had to be filed in circuit court because it was below $50,000. There's no question that $14,000 is below $50,000. And apparently in Wyoming, that was the cutoff. Now, here's the problem. There's a statute right on point, and the district court pointed it out and said, the court has exclusive jurisdiction in this matter. Property subject to forfeiture under this act may be seized by any law enforcement officer of the state upon process issued by any district court. So the court says we're a district court, we can do that. Boom, there you go. Now, seems pretty straightforward. And so while they're fighting over this, the parties apparently agreed to stipulate to the entry of a judgment in favor of the state and say, we're going to take it up on the sole issue that this is in the wrong court. Because if it's in the wrong court and this action is no good, I believe they would then have missed the deadline for filing to keep the money. I think that's why they did this, because I read the statute from Wyoming about how you seize money under civil asset forfeiture, and there are very, very strict timelines that it must be done in this time period. Now that we're talking about 2019, this is years ago, so I believe that's what they're getting at here. But the district court says, no, we've got jurisdiction because it says we've got jurisdiction. Look at Wyoming statute 35-7-1049. And it does say by any district court. So the parties stipulated to take that one question up. And so now the Wyoming Supreme Court is looking at the one question. And that is, did the district court have jurisdiction to hear this case? If yes, the state keeps the money. If no, the guy gets his money back. So the court talks about the standard review and talks about subject matter jurisdiction. And it says here that before the court can act on subject matter, it is fundamental to the operation of our judicial system that the court must have subject matter jurisdiction. It's well established that a judgment may properly be rendered against a party only if the court has authority to adjudicate the type of controversy involved in the action. And then they go through the whole rigmarole about how Wyoming courts derive their jurisdiction from the Constitution and other statutes as authorized by the Constitution and the legislature and so on. Circuit courts are statutorily created and have only limited original jurisdiction as provided by statute. In contrast to our presumption in favor of district court jurisdiction, circuit court jurisdiction is strictly construed. So it sounds to me like it's similar to Michigan's, but just reversed. The district courts are the ones with the most jurisdiction. The circuit courts are the smaller ones that have jurisdiction below a certain dollar value. And so Mr. Orozco is, as we say, hanging his hat entirely on the notion that this was brought in the wrong court and the district court wouldn't have jurisdiction over it because of the dollar value. But here's the thing. The Supreme Court looks at this and says, believe it or not, the district court ruled on it wrong, but we're going to still find a way for them to win. Don't worry about that. So it says, number one, the forfeiture statute does not grant exclusive jurisdiction over forfeiture actions to district courts. And it says the district court found the district courts have exclusive jurisdiction over forfeiture actions because of the language in the statute, which allows the seizure of property upon process issued by any district court or district court commissioner having jurisdiction over the property. Mr. Orozco argues that the court's reliance on this provision was misplaced because it does not apply to forfeiture proceedings and instead addresses only authority to seize the property, which is an interesting point. The state concedes that no provision in the forfeiture statute explicitly grants district courts exclusive jurisdiction over forfeiture proceedings, but it contends that given the process for seizing property and applying for its forfeiture and destruction, it makes sense that the legislature would have intended the district courts to have exclusive jurisdiction. But the court now says, when we interpret statutes, our goal is to give effect to the intent of the legislature, and we attempt to determine the legislature's intent based primarily on the plain and ordinary language. And it says, based on the forfeiture statute's plain language, we are unable to find a legislative intent to give district courts exclusive jurisdiction over forfeiture actions. Not exclusive, meaning that both courts would have it. And so they point out that as you go through statutes, it'll often say circuit courts do this, district courts do this, and they specify these things back and forth. However, in the forfeiture statute, it simply says the court having jurisdiction. And the Supreme Court is saying if they had wanted that to be only district courts or only circuit courts, it would say that right there. But instead it says the court having jurisdiction, which implies that it could be either circuit or district. So we're looking at Wyoming statute 35-7-1049, D and E, where it does say property taken or detained under the section shall not be subject to replevin, but is deemed to be in the custody of the commissioner, subject only to the orders and decrees of the court having jurisdiction. So they write, when the legislature specifically uses a word in one place, we will not interpret that word into other places where it was not used. So statutory construction, most people think, is very, very boring as to how you construe a statute. But here it is. You can find how interesting it is because of the fact that this entire case hinges on exactly what is meant by these words. So the court says, look, there is not the exclusive jurisdiction that the lower court thought there was, but there is jurisdiction because Wyoming statutes 5-9-128 does not grant circuit courts jurisdiction over civil forfeiture proceedings, and district courts therefore have general jurisdiction over the proceedings. The legislative grant of jurisdiction to circuit courts reads in relevant part that an action with a prayer for recovery is an amount not exceeding $50,000. So that's what he's getting at, Mr. Orozco, when he says, if it doesn't exceed 50, it's got to be in circuit court, right? But then it says actions to foreclose or enforce a lien on or security interest in personal property perfected in the Uniform Commercial Code. And it talks about other situations that fall under circuit court jurisdiction. And it says here, Mr. Orozco contends that the subsection A1 grant of jurisdiction over actions where the prayer for recovery is an amount not exceeding $50,000 gave the circuit court jurisdiction over this forfeiture proceeding because the currency totaled less than $50,000. The state argues that this provision is not applicable because a forfeiture proceeding is not an action that seeks damages. So there's a section of the statute that says if you are filing a lawsuit seeking damages above $50,000, you go here, below $50,000, you go here. This isn't an action seeking damages. This is an action seeking forfeiture. And those are two different things. So it says here the state argues provision is not applicable. We agree with the state. The forfeiture statute states that the proceedings and judgment of forfeiture shall be in rem and shall be against the property itself. This is simply a lawsuit against the property or against the money. An in rem proceeding is not one for damages. As one court explained, forfeiture actions are civil proceedings. However, forfeiture actions are also in rem proceedings. And what they're talking about there is that there's a lawsuit about a thing, and the thing is, in essence, the party to the suit, which gets you back to the caption, in the matter of U.S. currency totaling $14,245. So Wyoming statutes reflect both the legislature's understanding of this distinction and its intention to maintain it. So while subsection A1 grants circuit court jurisdiction over actions that assert a prayer for recovery, Other subsections identify other actions over which the circuit courts have jurisdiction, including actions to enforce liens where the amount of the lien does not exceed $50,000. Actions to enforce liens are in rem proceedings. So there you go. So we thus conclude the circuit courts do not have jurisdiction over forfeiture proceedings. The district court had general jurisdiction over the civil forfeiture proceeding. District courts have original jurisdiction in all cases and of all proceedings, according to another case statement, except those placed within the exclusive jurisdiction of another court, and that's from the Wyoming Constitution. So, people often say, Steve, you repeat yourself. I'm going to repeat myself right now. And I do it to clarify points, because I just spoke for a period of time and gave you a bunch of information. I'm now going to summarize it for you. So if you don't like me repeating stuff, hit stop. I'll give you half a second. There you go. Okay. Man's driving through Wyoming. Police officer pulls him over, routine traffic stop. Asks him a few questions, thinks something shady's going on, says, may I search your vehicle? The man says yes. Trooper calls him back up. Two guys search his vehicle. They find cash, $14,000. They think there's something unusual about that because he says he's traveling, but he doesn't have any luggage. He's got $14,000 in cash and rubber bands. That's suspicious. So they seize the cash, bring his vehicle back to an impound place, and somewhere along the line, they let a dog smell the money, and the dog gives them the old paws up. And they then seek to have the money forfeited because it's obviously tied to criminal activity involving drug trafficking. Obviously. And the state seizes the money. The state then files an action against the money. The state of Wyoming versus $14,245 in the matter of. In re. Mr. Orozco has the right to come in as a claimant and oppose that, and he came in too late. He got defaulted. So he's kind of behind the eight ball, as they say. However, they then sought to have the default set aside, and at that hearing, they also brought a motion to say this court is the wrong court. And Wyoming has got two sets of courts, and one court covers a certain jurisdiction money-wise, and another court covers the other jurisdiction money-wise, when you are seeking damages. And his entire argument was, the state is suing me for $14,000. You cannot do that in this court. Therefore, the lawsuit should be dismissed. The action should be dismissed. I should get my money back. I should be able to go on down the road, literally and figuratively. The state says, no, because the $14,000 threshold is only when you're seeking money damages. But when you're seeking what is, in essence, equitable relief, but some kind of non-monetary damages, you simply want the court to make an order. Here the court is asking to order that this money that was in his possession is now rightfully owned by the state. And the Supreme Court of Wyoming said that is the situation, and the amount of money that's in question does not affect this. What affects it is the nature of the action, and the nature of the action is a civil asset forfeiture, and the statute is clear that this is an appropriate place to bring that. So if we want to discuss why he hinged his entire case on one argument, the statute for civil asset forfeiture in Wyoming says that to bring the action, they must bring it within a certain period of time. And I believe that period of time had passed. So that if he won this motion, I believe he would have gotten his money back. But he didn't win the motion. He lost. So to summarize in a really, really short form here, is that the man's $14,245 was forfeited. That was upheld by the state of Wyoming, but it was not fought on the grounds of how righteous civil asset forfeiture was. It was fought on the grounds of whether or not it had been filed in the correct court. And that was it. So the man lost the $14,245 in the matter of the U.S. currency and the state of Wyoming. So Scott and Sean both sent it to me. I just read to you from the opinion of the Supreme Court of Wyoming. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. When you feel overwhelmed by life's challenges, look back at the past and remember difficult times you've survived.